admissibility of young people's statements is governed entirely by Section 146 of the Youth Criminal Justice Act. It only applies to young people who are under the age of 18 at the time the statement was taken, unless otherwise represented as over 18, pursuant to 146.8. What I mean by that is even if they're investigating a young person for a charge when they were 17, but they don't actually interview them until they're 18, they do not need to comply with 146. Also, if the young person lies about their age and represents that they're older, or if they look like they walked off the set of Duck Dynasty, you might forgive the police officers for not getting the date of birth in a timely fashion. So the section presumes that a youth statement made to a person in authority is inadmissible unless certain conditions are met, and that compliance with these conditions of admissibility must be proven beyond a reasonable doubt. And of course, the youth's waiver of his or her rights must be unequivocal. So 146 sub 2 states that when statements are admissible, no oral or written statement made by a young person who is less than 18 years old to a peace officer or to any other person who is in law, a person in authority, on the arrest, detention of the young person, or in circumstances where the peace officer or other persons has reasonable grounds for believing that the young person has committed an offense is admissible against the young person unless. So it has to be made to a person in authority, and it has to be upon arrest, detention, or in circumstances where they are a likely suspect. The conditions for admissibility are further listed as A, the statement was voluntary, B, the person to whom the statement was made has, before the statement was made, clearly explained to the young person in language appropriate to his or her age and understanding that the young person is under no obligation to make a statement. Any statement made by the young person may be used as evidence in proceedings against him or her. The young person has the right to consult counsel and a parent or other person in accordance with paragraph C. And any statement made by the young person is required to be made in the presence of counsel and any other person consulted in accordance with paragraph C, if any, unless the young person desires otherwise. And further, so C is the young person has, before the statement was made, been given a reasonable opportunity to consult with counsel and with a parent, or in the absence of a parent, an adult relative, or in the absence of either, appropriate adult, pardon me, chosen by the young person as long as that person is not a co-accused or under investigation in respect of the same offense. And lastly, if the young person consults a person in accordance with paragraph C, the young person is being given a reasonable opportunity to make the statement in the presence of that person. So that's the sections, and we are going to break them down into greater detail. So let's first talk about a person in authority. So persons in authority are usually persons who formally are engaged in the investigation, arrest, detention, examination, or prosecution of the accused. And it's well established who is a person in authority involves a subjectively held belief that it has some objective basis. And this is pursuant to the Supreme Court of Canada case of the Queen and Hodgson. The question of whether the accused reasonably believed the person could influence or control the proceedings against him or her. So Hodgson says a couple of important things here. One is that the evidence discloses a relationship of agency or close collaboration between the receiver of the statement and the police or prosecution, and that relationship was known to the accused. The receiver of that statement may then be considered a person in authority. The court also went on to say that there is no catalog of persons beyond a peace officer or prison guard who are automatically considered a person in authority solely by virtue of their status. So a parent, doctor, teacher, or employer may all be found to be persons in authority if the circumstances warrant, but their status or the mere fact that they may wield some personal authority over the accused is not sufficient to establish them as persons in authority for the purposes of the confession rule. So in terms of young people, who would typically be the kind of person that would be a person in authority apart from those police officer and prison guards? Well, some individuals are, again, obviously cops, guards, prosecutors, but the distinction between who is or is not a person in authority in law is the perceived ability to influence the criminal prosecution and whether that perception was reasonable, not whether the person had some personal authority over them. So let's talk about the obvious ones here, parents and guardians. So they can be deemed persons in authority in law. While parents obviously have substantial personal influence over their child's lives, the issue is whether the accused believed his or her parent could influence legal consequences or was otherwise acting as an agent of the state. So a good example of this is in the case of the Queen and AB from the Ontario Superior Court, in which leave to the Supreme Court of Canada was refused. In this case, the 13-year-old boy who was charged with sexual offenses, he had made admissions to both his mother and later on a doctor. At the time, the parent promised counseling and had no intention whatsoever of going to the police. It was the stepfather who came forward with the information a year later, and I believe that was because it was disclosed that the stepfather's biological daughter may have been a complainant. So the Court of Appeal held that the mother was not in a person in authority, as at the time the statement was made, there was no indication of any intention for the police to be called. After review of the jurisprudence, the court outlined 7 principles in considering who is a person in authority. So we're going to go through what those 7 principles are. So the court said that, as a general rule, person in authority is someone engaged in the arrest, detention, examination, or prosecution of the accused. When the word examination is used, I believe it to refer to the interrogation by police officers, detention or security guards, and members of the Crown Attorney's Office. In some circumstances, the complainant in a criminal prosecution may be considered to be a person in authority. The parent of an infant who is the injured party or the complainant in a criminal prosecution may be a person in authority. Such a conclusion, I would suggest, depends on the factual background. An inducement made by one who is not in authority, but made in the presence of persons in authority who do not dissent from it, may be deemed to have been made by a person in authority. In those circumstances, the person making the inducement can be considered as the agent of the person in authority. To put it another way, by the presence of those in authority, the person not in authority is closed with that authority. As a result, such a statement is suspect for the same reasons that a statement made in response to an inducement offered by a person in authority would be. The question as to whether the statement was made to a person in authority will be viewed subjectively, that is to say, from the point of view of the accused who made the statement. The court refers to the proper test that is given in Kaufman, Admissibility of Confessions in Criminal Matters at page 81. Did the accused truly believe at the time he made the declaration that the person he dealt with had some degree of power over him? A person who is to be a witness for the prosecution will not, as a general rule, be deemed to be a person in authority. And then lastly, as well as it has been determined that a psychiatrist, even when examining an accused to determine if he is a dangerous offender, will not be considered to be a person in authority, nor will a doctor who has examined the accused. Okay, so let's look at the obvious one, parents and guardians. So while the court didn't find the accused's mother in AB was a person in authority, a parent can become one where the young person reasonably perceives the parent as influential in the criminal process, or where the parent is acting as an agent of the state. So for instance, where a parent is enlisted by the police to help communicate the importance of telling the truth, in compliance with the provisions of the YCJ concerning the statement of young persons, that parent becomes a member of the police investigation team, albeit unwittingly. So what I'm referring to here is the young person's entitled to have a parent present, so that's for the purpose of the YCJ statement. But if the police enlist them for the purposes of getting the statement out of the young person, then yes, they can be a person in authority. And this was exactly the case in the case of SL from Ontario. The police enlisted the efforts of the father, who was in attendance as the reasonable or responsible adult under Section 56, as it then was at paragraph 53. And just so you know, Section 56 was the precursor to 146, and it has not changed really at all in terms of wording. So if you ever come across cases in talking about Section 56 under the old Young Offenders Act, it is equally applicable today. So the court says the officers asked to speak to the accused's father alone and indicated to him that they felt that there was more information, that they wanted the truth. And from that point, they indicated the father was very cooperative in that he went back into the interview room and advised his son of the importance of telling the truth. That is the role the accused father was called upon to play to a fairly extensive extent during the interviews of the evening of November 2nd and the morning of November 3rd. He was made to be a member of the investigation team in attempting to elicit a statement out of the accused. In another case, this is a caregiver. So this wasn't a social worker, wasn't a foster parent per se. Rather, the natural parent had left the young person in the care of a family friend. And so the court in the case of GFD from the British Columbia Court of Appeal held, I find therefore that once DF, the guardian, decided that her intention was to turn BAS over to the police, no matter how well-intentioned were her motives to instill a sense of honesty in BAS, she stopped being a, quote, mother, seeking solutions to her child's problems, and became a, quote, person in authority in law, eliciting admissions from a young person without adhering to the requirements set out in Section 146 of the Youth Criminal Justice Act. So it would appear to be that if the parent's intention is to turn them over, then they are becoming an agent of the state. Another common example of persons in authority, obviously school officials do wield some personal authority, but and especially in cases where you have an SRO on campus, this is where you might find that a principal or a teacher might be caught by this. So in the case of RS from the Ontario Court of Justice, 3 youths were interviewed by the vice principal in relation to a break and enter. Prior to interviewing the boys, he had spoken with police. Court held that the vice principal was a person in authority, and by the way, only one young person actually testified in the voir dire. In the case at bar, the investigation by the principal of the defendants after meeting with the investigating officer, where the principal knew he would be sharing the fruits of the investigation with the officer, takes the role of the principal beyond that of a normal discipline and into the time when consequences are inevitable and the principal becomes an agent of the police in detecting crime. Other instances where a person might be in a position of authority for the purposes of statements, obviously probation order officers, in the case of Queen and CH, obviously probation officers have the power to lay breach charges. And social workers, like guardians or parents, they too can be found to be persons in authority. I didn't go through a long list of who could be, but I'm sure if you did your own research, you might find other instances where they might be in persons in authority, but I just provided the ones that were the most common. Okay, so let's talk a little bit about voluntariness, and I'm not going to dwell on this too much because voluntariness is something that applies in adult court as well, so you should all be familiar with it already. So the law regarding the voluntariness of the statements applies equally to youth. The immaturity, naivety, and dependency of youth make them particularly susceptible to the influence of others. The factors that you would ordinarily consider in adult cases may be more pronounced with youth as they are more vulnerable to suggestion or influence. The relevant factors in determining voluntariness is found in the Supreme Court of Canada case of the Queen and Oikel, which obviously is an adult case. And they list a few factors, including threats, promises, oppression, the operating mind requirement, and police trickery. Examples of oppressive circumstances might include things like depriving young people of food, clothing, water, sleep, or medical attention, denying the young person access to counsel, parent, or other adult, excessively aggressive, intimidating questioning over a long period of time, and the use of non-existent evidence. So this picture here actually really well encapsulates the oppressive circumstances. So I'm going to give you a quick war story here. I once had a young person who was in this exact same situation minus the table. He was put in a chair in the corner. The police officer had pulled the chair right up and leaned in just like this officer had. And for a period of almost 2 hours, the police officer was interrogating him in relation to a sexual assault of a minor. And what he was doing, he was giving no opportunity for the young person to deny his guilt. He gave him only 2 options. He said, either you are this was kind of, you're just figuring out your sexuality and this was a mistake and it's not something you're ever going to do again, or you're a pedophile and I should be locking you up for the rest of your life. I'm not really speaking too much in hyperbole, I'm paraphrasing though, but he did do that. Every time the young person tried to state that he wasn't A or B, but in fact that he was innocent, the police officer would cut him off every time he tried to protest his innocence. At some point after the 2 hours, the officer was very aggressive with him in terms of cutting him off and getting angry with him for not coming clean, as he called it. And of course, the young man eventually confessed to whatever the police officer wanted to hear. And he chose the category, the lesser of the two evils, that this was, an accident kind of thing and it would never happen again. After the police officer left the room, he then crumpled onto the floor into the fetal position and began to rock back and forth. At trial, Judge Goss, she had no difficulty in excluding the evidence, and in fact further held that had she herself been in that situation, she might have confessed to sexually assaulting the minor herself. So be aware of the oppressive circumstances in the video. So young people are particularly vulnerable when they're questioned by police. Any factors commonly described in adult cases tend to be more impactful upon a young person's will. Young people are more likely to appease persons in authority, and this comes from the Supreme Court of Canada case in JTJ. What might be deemed oppressive to a young person may depend on things like the age, gender, maturity, education, degree of sophistication, and cognitive function. 146.2b, the remaining sections of 146.2 fall under the umbrella of voluntariness and therefore share the exact same evidentiary standard of proof beyond a reasonable doubt, and that's pursuant to the Supreme Court of Canada case of LTH, which we'll talk about in a couple of slides now. Non-compliance with any provisions under Section 146 will result in the statement being rendered inadmissible. So 146 sub 2b states, the person to whom the statement was made has, before the statement was made, clearly explained to the young person in language appropriate to his or her age and understanding that no obligation to make the statement, the evidence would be used against them at trial, the right to consult with a parent, lawyer, and have those individuals present. I'm not going to repeat these again because it was earlier on in the slide. So let's talk about the language a young person can understand. And this picture here is actually very apt. You have a young person who's probably scared to death of what's going on, and pretty much everything's going through one ear and out the other, and everything sounds like Charlie Brown's teacher. So the leading case on use statements is the Queen and LTH from 2008, Supreme Court of Canada. In this case, the majority determined that the Crown must prove compliance with 146.2 beyond a reasonable doubt. As such, the Crown must prove that the young person's rights were clearly explained to a young person in language tailored to the understanding of the young person. So a prerequisite to this would be an inquiry into the young person's level of understanding. And the court also found that simply mere reading of the young person's rights is not going to suffice. So paragraph 23, the court states, the kind of reasonable efforts that must be made by police officers were ably summarized in the case of the Queen and CG. And I recommend that if you have to argue this, you also refer to CG itself. Quoting that same case, persons in authority taking statements must learn something about the educational level of the child, the language and vocabulary skills of the child, his faculties of understanding, his emotional state at the time. These inquiries do not call for the intervention of a psychologist or a telephone call to the school teacher or even a parent, but they do require enough conversation with the young person to permit the officer to determine how many phrases must be explained and to what extent he must use ordinary or street language or even slang to be sure the child understands what is being said. In addition, the court reaffirmed their earlier decision in JTJ that young people will be unfamiliar with their rights and more readily influenced by persons in authority. As Corey J. explained in JTJ at page 766, Parliament has recognized the problems and difficulties that beset young people when confronted with authority. A young person is usually far more easily impressed and influenced by authoritarian figures. No matter what the bravado or braggadocio that the young people may display, it is unlikely they will appreciate their legal rights in a general sense or the consequences of oral statements made to persons in authority. Certainly, they would not appreciate the nature of the rights to the same extent as would most adults. Teenagers may also be more susceptible to subtle threats arising from their surroundings and the presence of persons in authority. A young person may be more inclined to make a statement even though it is false in order to please an authoritarian figure. It was no doubt in recognition of the additional pressures and problems the young people that led Parliament to enact this code of procedure. And lastly, at paragraph 27, the court in LTH affirms an earlier decision. The reading of a standardized form will not normally suffice in itself to establish the sufficiency of the caution required in 146(2)(b). Persons in authority must, in addition, acquire some insights into the level of comprehension of the young person concerned, since the mandatory explanation must be appropriate to the age and understanding of that young person. In the words of the Manitoba Court of Appeal in the Queen and BSM, the simple reading of an appropriate waiver form to an accused person will not generally constitute a clear explanation of his rights or the consequences of signing a waiver. What will constitute clear explanation will depend on the facts of a particular case. I would suggest that the mere reading of a waiver form accompanied by the repeated question, "Do you understand?" would normally fall short of satisfying the statutory requirements. Parliament has expressly stated that young people require more than the offering of information. They require not just explanations, but clear explanations that they are able to understand. So let's talk a bit about evidence of understanding. So while the ability of a young person to recite back to the police what was explained to them is not a requirement, it can assist in determining the young person's comprehension was sufficient. However, counsel must be alert that young people, particularly those with fetal alcohol spectrum disorder, have become very good at parroting, but yet have no understanding of what they've repeated. And this is very common with FASD kids. They don't want to be looked at as being stupid by their peers or other adults, so they will often simply repeat things that they have no understanding of. So if you hear the repeating of words like evidence and any proceedings, that should be an alarm bell for you, because that does not demonstrate that they understand the meaning of either. And there's a case called the Queen and OK from British Columbia that although the police were careful to inform the young person of his rights under 146, and they had him repeat it back what each meant, the court found the young person did not understand them in a meaningful way. So things like evidence of learning disabilities or impaired comprehension will go a long way in refuting any assertion that the young person understood the words he repeated. Now, talking about the right to counsel and a parent, 146(2)(b)(3) requires that the young person be advised that he or she has the right to consult with a lawyer and a parent or other person. Any suggestion that this is an either-or right will fail the informational component of Section 146, and that's referred to in the case of the Queen and KL from the Ontario Court of Justice. So let's talk a little bit about the right to a parent. So in addition to advising of this right to consult with a parent, the police must also provide a reasonable opportunity to access this parent or other reasonable adult. So in the case of the Queen and DDT, which is from Alberta Provincial Court, the failure of the police to inform the youth of the father's presence prior to the obtaining of a statement from him, and the failure to provide the youth with a reasonable opportunity to consult with a parent breached Section 146 of the YCJ. So what happened was I think it was the dad had shown up at the police station. The police were aware that he had shown up at the police station, but they failed to advise the young person. So the young person didn't know that the parent was there and could access them. There's also another case of the Queen and BCW from the Manitoba Court of Appeal as well. So what's the role of the parent of being there to consult with them and having them present? Well, the purpose here is that a parent, being older and wiser, has the ability to assist the young person in the exercise of his or her rights. Parents, because they're adults, may better understand the jeopardy the young person faces, the court process, and may be able to assist in obtaining counsel for the young person. So the presence of the parent or adult during a statement is to assist the young person, not the police. Therefore, any attempt to deter the adult from advocating for the young person during a statement undermines the right to the parent. And this also applies equally to the care of to child welfare workers. And I did have one instance where in the videotape statement, I had given legal advice to both the young person and the social worker. And the social worker kept interjecting and said, well, you know, we already spoke to a lawyer. We're not supposed to be talking to you. And if you're going to keep talking, we need the lawyer present. And the police officer told her that her job there is to be a witness. And if she continues to interject, that she will be asked to leave. Needless to say, the Crown made no attempt to get the statement in. Right to counsel. Well, the right to counsel is explicitly enshrined in Section 146 and therefore subsumes Section 10 of the Charter. Therefore, if we're talking about statements, Charter notice is not required for the exclusion of the statements. And of course, the Crown bears the onus of proving compliance beyond a reasonable doubt, as opposed to under Section 10, the onus would be on defense counsel to establish that. But be aware that unlike Section 10, compliance with 146 only applies to statements and not the exclusion of other types of evidence, like for example, breath tests. The young person also has a right to counsel of their choice and must be given a reasonable opportunity to contact them. So in the case of KL, which we spoke about near the beginning, the police were less than diligent in helping the young person speak with counsel of their choice. And when offered duty counsel, the court was not satisfied the young person understood what duty counsel was. In another case of the Queen and DRB from British Columbia Youth Court, the accused was arrested and given his charter warnings. At the police station, the youth was given an opportunity to phone a lawyer that he was unable to reach. He informed the police that his lawyer was unavailable. However, the police made no effort to help him contact another lawyer or duty counsel. So that failed the right to counsel requirement as well. Tainting doctrine, as you know, the fruit of the forbidden tree. Subsequent statements made after non-compliance with an earlier statement will likely make the subsequent statement inadmissible. In order to establish tainting did not occur, there must be a secondary caution, and young person must be made to understand that notwithstanding anything said earlier, any future statements may be held admissible in court. Now, in the case of KL, which we talked about near the very beginning, the Crown argues that no evidence was called by the defense to establish that the earlier dealings with other officers influenced the giving of the statement to Detective Constable Mounsey. The court is mindful, however, the onus remains on the Crown to prove that the earlier police contact did not taint the statement provided by the young person to Detective Constable Mounsey. So the exception to 146 is the spontaneous statements. So where the young person makes a statement prior to their ability to comply with the requirements in 146. 146.3 says that the requirements set out in paragraphs 2B to D do not apply in respect of oral statements if they are made spontaneously by the young person to a peace officer or other person in authority before that person has had a reasonable opportunity to comply with those requirements. Statements made in response to police questioning are governed by 146.2. Statements unprompted by police questions are admissible where police have not had a reasonable opportunity to conform with Section 146. So simply put, if the cop asks the question and 146 is not complied with, then the statement's not going to be admissible. So it's only ones where it's entirely spontaneous. So in the case of KL that we talked about, the young person made statements in the back of the police car. The young person was read his charter rights, but police had not yet complied with 146. There was no evidence the officer had asked any questions or there was an oppressive atmosphere. So the court found when the young person made these utterances, he acted entirely from natural impulse without any external stimulus or constraint. Similarly, in the KO case that we spoke about moments ago as well, one of the three accused KRK during transfer to the detachment made an inculpatory statement. The court stated, I have no reasonable doubt that the spontaneous utterances made by Mr. KRK to Constable LeBrun, as Constable LeBrun testified, that is, not in response to any questions by her or from her, but made spontaneously on Mr. K.R.K.'s own volition without prompting. All right, so the young person's being advised of their rights, and now we're at the part of the waiver form. So section 146 sub 4 states that a young person may waive their rights under 2C or D, but any such waiver must be recorded on videotape or audio tape, or must be in writing and contain statements signed by the young person that he or she has been informed of the right being waived. So just to be clear, 2C and D is the whole consulting a parent / lawyer on having those individuals present. 146 sub 5, when a waiver of rights under paragraph 2C or D, again regarding the parent and lawyer, is not made in accordance with subsection 4 owing to a technical irregularity, the Youth Justice Court may determine the waiver is valid if it is satisfied that the young person was informed of his or her rights and voluntarily waived them. So because the standard of proof for a valid waiver and the enhanced procedural protections guaranteed to young people, police generally obtain the waiver both in writing as well as audio or video recorded. So when you get disclosure, you're going to see the 5-page form that's being filled out, and then you're also going to see a video. RCMP tend to do this more by way of audio. In the major cities of Edmonton, Calgary, I'm not familiar of any instance where a young person's statement was not recorded in addition to the written waiver. So in order for the waiver to be valid, there must be clear and unequivocal evidence that the person is waiving the procedural safeguard and is doing so with full knowledge of the rights and the rights the procedure was enacted to protect, and of the effect of the waiver will have on these rights in the process. And that comes from Cromporney versus Canada in the Supreme Court of Canada. Justice Fish, on behalf of the majority in LTH, paragraph 7 states that manifestly, where Parliament has specifically sought to endow young persons with enhanced procedural protections, this high standard has not been satisfied if the court is left with a reasonable doubt whether the requirements set out in Cromporney and subsequently reaffirmed have been met. So let's talk a little bit then about technical irregularities. So 146 sub 6 states, when there has been a technical irregularity in complying with paragraphs 2B to D, the Youth Justice Court may admit into evidence a statement referred to in subsection 2, if satisfied that the admission of the statement would not bring into disrepute the principle that young persons are entitled to enhanced procedural protection to ensure that they are treated fairly and that their rights are protected. So what constitutes a technical irregularity must be related to the informational or implementation component of the right to consult with counsel or a parent. The irregularity might be something like not crossing a T or dotting an I on the form, or a glitch in the recording. However, an irregularity that affects the substantive right of the young person will not be saved by 146 sub 6. And I'll give you a couple of examples here. So in the case of the Queen and SS from the Ontario Court of Appeal, the police omitted to tell the respondent about the requirement that any statement must be made in the presence of a consulted third party, and that the form was deficient in this regard. Section 146 creates a consultation right and an implementation right. Failure to inform the young person of the requirement of the presence of a consulted person during a statement offends 146 2B and is not saved by 146 6. A similar finding occurred in the case of the Queen and NC, which was an Ontario Superior Court decision in which the court states, the right to have legal counsel or a person actually present during questioning is a particular right young persons have that adults do not. I cannot regard the failure to advise of the rights a technical irregularity within the meaning of section 146 sub 6 of the YCJ. So let's talk a little bit about statements made under duress. So even if the statement is not made to a person in authority, then it could be found to be made under duress. So 146 sub 7 says, a Youth Justice Court judge may rule inadmissible in any proceedings under this Act a statement made by the young person in respect of whom the proceedings are taken if the young person satisfies the judge that the statement was made under duress imposed by any person who is not in law or person in authority. So you'll note the onus is different here. So with the rest of 146, it's proof beyond a reasonable doubt by the Crown. However, the onus is on the defense to establish duress. So even where the young person received the statement is not found to be a person in authority in law, if that person influences the young person so as to pressure or compel the giving of the statement, then it may be ruled inadmissible. Going back to I think the first case or second case that we talked about earlier, the case of GFD, and this was where they found that the young person was making a statement to a person in authority because that caregiver had the intention of turning her over. So in this, with respect to the duress aspect of it, the 13-year-old made inculpatory statements to the caregiver about an assault that occurred with other girls. The caregiver angrily confronted the young person, eliciting both an admission and an apology letter to the complainant, which was then shared with the police. In this case, the source of duress was the power of the caregiver to place the young person in foster care. So this was an instance where the natural parent had left the girl with a friend of the family's as kind of a last resort. The above section 146 sub 7 therefore suggests that there is no need to enter into an inquiry if the person to whom the statement is made is in fact a person in authority in law. If the court is satisfied that the particular statement was made under duress by any person. It strikes me, therefore, that if I find in the circumstances of this case that the statements made by BAS to DF were made under duress, I can rule those statements inadmissible without having to get into the inquiry as to whether or not DR, meaning DF, was a person in authority who was forced to comply with the provisions of Section 146. The court further went on to say, I further find that in the mind of BAS, there was always the lurking threat that DF as caregiver was a last resort, and failure to do her bidding could result in her being placed in a foster home in Ontario. And I make this finding contrary to her indication to Crown Counsel that this was not the case. However, it is to be noted that DF volunteered that this was always a lurking threat over the two children. And given BAS' young age, I find that it must have influenced her decision to cooperate with DF when she demanded it. It is also noteworthy DF's lectures to BAS about honesty and morality, which finally led to a full confession and the writing of a letter of apology. It strikes me that without informing BAS of her intention to turn her over to the police if she admitted what she had done and have her agree to voluntarily make an admission, regardless, all these lectures can be construed as implied threats, pardon me, for BAS to confess. Similarly, in the case of TA, which comes from our own Alberta Court of Appeal, this is a situation where a taxi driver had been stabbed, and the 15-year-old was found by a homeowner, a witness, banging on his garage door. This witness spotted the young person with bloody hands and ordered him to submit to searches for weapons. He confiscated the young person's shoes so he couldn't leave. And upon realizing the young person was the likely suspect of the stabbing, the witness began surreptitiously recording the conversation. So I think he had heard on the radio that this stabbing had just occurred. So the witness offered the young person a cigarette and beer and began prompting him to tell the story, even calling the young person retarded. When the young person asked if he could stand for a bit, he was told by the witness, no, no, sit down, stay there, don't move, and that's all you get. I let you into my fucking garage, so stay right there, don't move. The Court of Appeal accepted the trial judge's finding of fact that, turning to the circumstances captured in the surreptitious recording, the trial judge highlighted the language Mr. Jolly used when interacting with TA. Sit down, stay there, don't move, man, please don't play a game, don't make me. You've got to just keep sitting there, right there. I will find your ride home, but you fucking don't move off that seat. You can sit there and don't ask me what to do. While she recognized that Mr. Jolly said some of these things after TA had already confessed to attacking the cab driver, She believed these statements reflected the overall dynamic between Mr. Jolly and TA. So the court refused to overturn the trial judge's ruling on admissibility. The Court of Appeal also held that the exclusionary remedy under 146 of the YCJA required that the young person satisfy the court that he or she made a statement under duress. So now that we've gone over all these provisions under 146, I'm going to talk to you a little bit about some practice tips for counsel. So if you receive a call from a young person who's under the age of 18, who is likely to be interviewed by police, it is important to explain to the young person about 146. Because of their vulnerabilities, it's up to you to ensure they understand their rights. So like the police officer, you're going to have to adjust your language to the level of understanding of the accused. So you're going to have to figure out what level of understanding they have, their education, any deficits they have, in order to make sure that they actually understand the advice that you're giving them. So you should explain to the young person the sort of tricks police might employ and why police might insist on getting a statement. The way I word it to my clients when they call is, well, you know, if the police had such great evidence, they wouldn't need to talk to you. So the only reason they're talking to you is because they want you to put your foot in your mouth. So you need to shut up. You are to look at your feet and keep saying that you don't wish to make a statement. It's also important to let the young person know the types of tricks that police use, that they might use false evidence or allude to having video or DNA and that kind of thing. So even if they say that, they tell you that they got you on everything, they don't. Because again, they wouldn't need that statement. You'll need to explain to them about the form that the police will have the young person sign, acknowledging his rights and waiver of them. It's a 5-page form. You should tell them that they are not required to sign anything other than their release papers. Because the waiver section under 146 only applies to the consultation portion, there is no explicit waiver of the right to remain silent. So what I often tell the client is to write it on the form right after the part where you say, I want a lawyer present before I say or write anything. You write, but I don't wish to make a statement. Always instruct the young person to tick yes to the questions of wanting a parent and lawyer to speak to and to have both of them present. So unless there is a homicide, I don't go down to the police station. So counsel may not need to attend the police station, but simply to indicate to police that the young person is not talking even if you are present. So sometimes you can get the police officer on the phone in order for you to tell a police officer you've given the legal advice. Little Johnny has agreed that he's not going to be talking, but if you continue to pursue him with questions, that I need to be there. Oftentimes police have no interest in talking to counsel, so you're going to have to explain this to the young person. Basically, look, you and I have just agreed that you're not making a statement, right? So I'm not coming down to the station just to sit there to say he's not making a statement. You understand? But sometimes your client might have significant cognitive impairments that you may have to simplify or be creative with your advice. So I have in a few instances where it's clear that the young person is not understanding what I'm saying, and I go over it with them over and over again, and I say, okay, what you're going to do as soon as you get back in the interview room, as soon as the officer opens his mouth, you're going to stick your fingers in your ear. Yes, I do tell them that. You're going to stick your fingers in your ear, and you're going to keep chanting, I'm not making a statement, and you can't make me, and my lawyer has to be present if you keep talking. And I get them to repeat that to me until I'm satisfied they have it memorized, and then they go back in. I also tell them that if the police are not respecting your right to silence, that you can ask to speak to me again and I will talk to you again. And this will eventually make the police officer go away. If there's a parent there, that's better, because you can provide the identical advice to them in the event that the parent needs to intervene on the young person's behalf. And this also applies to social workers as well. And I actually did have one instance where I gave the advice of sticking your fingers in your ear and I got the video, and sure enough, my client did that. The police officer looked a little bit perturbed by that. But I can tell you right now, if for some reason the young person does utter a statement after doing something like that, any judge that sees a video of that, there's no way the judge is letting that in. So in instances where counsel might attend, counsel can go into the interview room and state on the recording that the young person does not wish to make a statement, and should the police attempt to question the young person, the lawyer's attendance is required. My preference, though, is to do it in writing to prevent any opportunities of the young person to spontaneously start talking while being recorded. You might have a young person who's pretty hyper, who likes to fill blank spaces, might be a little bit too chatty. This way you make sure that that's not going to happen, because if the young person says something while you're in the room with them, that statement's probably going in. So what I do in writing is, I, John Doe, date of birth, do not want to talk to the police. If you ignore my wishes further, I want my lawyer present. I also do not consent to any searches of my person or my property. I do not consent to the seizure of any bodily substances. And then have the, do not take my cooperation as consent of the above. And then I have the young person sign it. I sign it as well. I take a picture of it with my cell phone, and then I hand the copy over to the police officer. So that pretty much shuts down the interview right there. In preparing for trial, getting a statement admitted at trial is very difficult for the Crown to do, given this reasonable doubt standard. So few Crowns will even try. And in most instances, one can determine the admissibility of the statement in the first few minutes of the recording. Now, obviously, for things like threats, promises, and oppressive circumstances, you might have to look through the whole video, but you can usually get a general feel whether or not they complied with 146 just by looking at them going through the waiver form. So things to look for would be mere reading of the provisions and asking the young person if they understand. So just reciting what's on the form and saying, do you understand? Do they make any inquiries about the young person's ability to understand their level of education, age, maturity, mental health diagnosis? Maybe they've never been involved in the criminal justice system before. Does the young person appear tired or fidgety or distracted? If it's any of those circumstances, they're probably not listening to you and obviously not comprehending. Does the young person recite back what was read to him in his own words, or are they simply just repeating what was said? Does the young person appear confused or express some kind of misunderstandings? And that could be about a number of things, like what's duty counsel? Most people don't even know what duty counsel is. What opportunities were given to access a lawyer and or parent? And if a parent was present, did the police interfere with the parental obligation to affirm the young person's rights and provide advice in private? Or is the parent acting as an agent of the state? So you should be able to get a feel for whether or not the Crown even has a chance of admitting that into trial. So in conclusion, no statement made by a young person under the age of 18 to a person in authority is admissible at trial unless 146 of the YCJ is complied with. A person is in a position of authority in law if the young person reasonably believes that the individual has influence upon the investigation, arrest, or detention of the young person, or the individual is acting as the agent for the authorities. Compliance with 146.2 must be proven beyond a reasonable doubt. Authorities must explain to young people in language they can understand their rights and protections under 146.2 of the YCJ, and must make reasonable inquiries to ascertain the young person's ability to comprehend. A young person must be told they have the right to consult with a lawyer and a parent, adult relative, or other appropriate adult. The young person must be further told they must have a reasonable opportunity to consult with these individuals and have them present before a statement is made. The waiver of the informational or implementation components of the right to consult must be done by video or audio or in writing. A youth court must still refuse admission of the statement if it were made under duress to a person who is not in law a person in authority, and that would be a different onus on the accused. And lastly, that spontaneous utterances before a reasonable opportunity to comply with Section 146 are admissible.